the Center for Disability and Elder Law. Please keep in mind, similar to what Udoka and Julie previously said, I'm here to provide information. I can't, oh, and Cheryl Lipton, our senior attorney, I forgot to update this with my name. Cheryl Lipton is um, now running our guardianship help desk, and she is a terrific attorney who put this presentation together, and I am borrowing it from her. Um, I can only give information. I can't give advice or answer questions about any specific legal issues. Also because this is a very public forum and I wouldn't want to do that. So educational purposes only. So our organization serves low-income seniors and people with disabilities in Cook County. Most of our clients are over 60 or living with a permanent disability. However, we also represent families in petitions for guardianship. To offer representation, our office does assess based on income and asset eligibility. However, our adult guardianship help desk at the Daily Center is open to anyone who needs assistance with guardianship paperwork, regardless of income or assets, and we provide all of the forms and instructions to file yourself. In addition to guardianship, we also assist with end of life planning, which includes powers of attorney, which I'll be talking about, various home ownership and other real property issues, very simple divorces, collections issues, consumer debt issues. So when is guardianship needed? So the law in Illinois presumes that once a person turns 18, that they are able to make their own decisions. That's the presumption, regardless of what someone's condition or health has been since birth. And so the only way to change that presumption is to petition the court and to ask a judge to determine if the person has a disability that requires a guardian. So the judge is going to make a decision primarily based on a report from the doctor. Is the person with the disability totally or partially incapable of making personal and financial decisions? And so it's not that someone makes poor decisions, it's whether or not they understand the consequence of their decisions. And so we find with families who have been caring for children with disabilities their entire lives, that 18th birthday comes around and that presumption kicks in, and guardianship really is the only option for someone who is totally incapable of making personal and financial decisions. So adult guardianship is appointing a guardian, a decision maker, to make healthcare decisions where the person is unable to make or communicate responsible decisions due to regarding their personal care. And like I said, it's whether someone understands the consequences and whether they can communicate those decisions, not about making decisions that you wouldn't necessarily agree with. It's about the ability to understand consequences of what would happen if you do something. There are alternatives to guardianship. These are available for adults with a disability who do have the ability to make their own decisions, but choose to appoint another person to help them. For the most common form of advanced directives, which is the power of attorney. And there are two kinds of powers of attorney. There's power of attorney for healthcare, and there's power of attorney for property. But the adult can only sign a power of attorney if they have capacity, which very basically is the ability to appreciate, make and understand decisions. And so that can be hard to assess sometimes. And the first thing that we will admit in our office is that we're not doctors, we're just lawyers. And so anytime that we're not sure, we're almost always going to ask to get either that report from the doctor or a letter from the doctor, getting their opinion on whether or not a person is able to make their own decisions and whether powers of attorney or guardianship might be appropriate. There is also a newer law that began in 2022 that is a different kind of advanced directive. It's a supported decision-making document, and that is appropriate for someone where they might be in between the need for a guardianship and the ability to sign a power of attorney, where they might not have the capacity for the power of attorney or might not be ready for the power of attorney yet. However, they can sign a document, um, the supportive decision-making document, and what that does is it says what the person would like help with, who they would want to help them to make decisions, and what kind of decisions that they would want support with. The idea really being to preserve autonomy wherever possible and to give a young adult with a disability support and not necessarily going through the entire guardianship process, which can be very restrictive, um, and where powers of attorney might not be appropriate at that time. And that's an assessment that needs to be made on a case-by-case basis, really looking at the ability of the young adult and whether or not they are able to sign one of these documents. There are some great resources to better understand supported decision making. The Illinois Guardianship and Advocacy Commission is a wonderful organization, and their website has a significant amount of resources about these forms. And it is also a form that my office can sometimes prepare for clients if they are seeking, our advisors seeking representation, and they're not sure about guardianship, and where this may be a better alternative. We also assist with powers of attorney where they are appropriate. So before I start talking a little more in depth about guardianship, just some terminology. Before a guardian is appointed, you have the petitioner, who is the person asking to become the guardian, and the respondent, who is the alleged person with a disability, or ADP as we call them. And if a guardian is appointed, then there is a guardian and the ward, the person with a disability who is subject to the guardianship. So there are different types of guardianship. There's guardianship of the person only. The guardian of the person makes healthcare decisions, decides where the person lives, can make very basic financial decisions. Guardianship of the estate is necessary when the person with a disability has income or assets that require court oversight. You can either have plenary guardianship, full guardianship, or limited guardianship. This largely depends on the doctor's opinion of the abilities of the person with a disability, whether they are totally or partially incapable of making personal and financial decisions. And if the answer from the doctor is that they're partially incapable, then limited guardianship may be appropriate, and the guardian would only be empowered to assist with those decisions that the doctor has said that the person with a disability is not able to make. In emergency situations, temporary guardianship may also be appropriate, and a temporary guardianship has to be filed with a full guardianship petition, and it's only for occasions where there's an active emergency that requires immediate attention from the court. So we've talked a lot about the person with the disability who can serve as guardian. It is a person over the age of 18 who lives in the United States, and that is, it is not a legal residency requirement. It's just whether or not you reside here in the U.S., who has not been convicted of a felony, although there are some exceptions to that. Some felony convictions are an absolute bar to serving as guardian. Other felonies, the judge will conduct a separate hearing to determine what type of felony it was and whether or not, despite the conviction, the proposed guardian is still an appropriate person to serve. And the guardian must be of sound mind and not have been found disabled themselves in a similar court proceeding. Um, like I said, the doctor's report, the report of physician, is the most important piece of evidence that the judge is going to look at, and is a piece of evidence that we'll look at in determining if we're going to take the case, and also if we think that potentially powers of attorney or supportive decision making might be more appropriate. And the doctor is going to opine on the nature of the disability, is going to give that opinion on whether the person is totally or partially unable to make decisions. The doctor will give an opinion on what the most suitable living arrangement is. And a doctor's report essentially expires, and it can only be used for 3 months. And so if once the doctor's report is obtained, then you have to petition for guardianship before it expires after 3 months. And if it expires, then you just need to get a new report. A guardian ad litem, once the case is filed, if the person with a disability can come to court, and in Cook County, all hearings are on Zoom. And I should say that when I'm talking about the court process, I'm only going to be talking about the procedures in Cook County. And some of these procedures will differ outside of Cook County. The law will largely be the same, but the process can be very different outside of Cook, and I cannot speak to other counties, just Cook County. But the if the person with a disability appears in court, which means appearing on Zoom, the judge usually will not appoint a guardian ad litem. But if the person with a disability can't appear in front of the judge, or if there's any kind of conflict, if the person with a disability says they don't want a guardian, or that they don't want the petitioner to be their guardian, if another family member comes forward and says they would rather be the guardian instead of the petitioner, the judge will appoint that guardian ad litem to do a home visit, to conduct interviews, and report back to the court what their opinion is. And if the respondent does not have funds to pay for the GAL, then the petitioner will be responsible. Although there are pro bono GALs in Cook County. So the guardianship process in Cook County, you're going to fill out the required forms and file with the court. If necessary, there is a fee waiver application. It's about $390 in Cook County to file, plus the fee to the sheriff. You have to then take that summons to the sheriff because due process has to be met, and the person with a disability does need to be served with a summons. Notice has to be given to the nearest blood relatives, and then you appear at the hearing. The judge will review the evidence, make sure the documents are correct, and if everything is in order, then the judge will appoint the petitioner guardian and issue letters of office, which is the proof of guardianship. Like I said, the fees are about $390. The sheriff is $60, or they actually just changed it. If you e-file it, it's $35. And you can ask the court to waive fees based on income and financial hardship. The court will allow co-guardians. Generally, that ends up being parents. Sometimes that's a parent and maybe an adult sibling who's very active. The judges in Cook County will not let you do more than two. So we have had families who want both parents and an adult sibling to serve. Judges will not allow that. They only want a maximum of two people serving at a time. And those two people ideally will be able to make joint decisions and agree with one another. If something happens to the original guardian due to death, their own disability, or if they choose to resign, if it becomes too much, then there does need to be a backup guardian, a successor guardian who comes in. And they have to go through the same process of showing the court that They're over 18, not living with a permanent disability, residing in the United States, and do not have that felony conviction. There's also something called a standby guardian, which is someone that can step in temporarily if they're needed. And then they would still have to petition to become the permanent guardian if that became necessary. Like I said, due process does apply here. This is still a court case. And so service has to be affected by the sheriff or a process server. And the person with a disability has to already be 18 to get served. So there usually is a small gap between turning 18 and the actual guardianship hearing because that step must be taken. Um, the person with a disability has a right to attend the hearing, has a right to representation by an attorney, and will have an attorney appointed if they ask for one. They have a right to trial by jury, although that's extraordinarily rare. They have a right to an independent medical examination if they don't like the doctor's report that has been presented to the court. And they have the ability to present evidence and confront and cross-examine witnesses. And if the guardian is appointed, then the driver's license will be revoked. If there is a driver's license, it would be revoked by the Secretary of State, and a gun card would also be revoked. And so if a guardian is appointed, that notice goes to the Secretary of State and the Illinois State Police so that either of those licenses can be revoked, unless it's a limited guardianship that specifically says that the person can keep those licenses. But it would have to be very specific in the order, and separate evidence would probably have to be submitted to the judge to allow that. Everything ultimately is up to the judge. So at the court hearing, the judge decides, does the respondent have a disability? They're going to rely on the physician's report that gets read into the record. But they also talk with the person with a disability to both explain their rights to them and if they understand what's going on, if they object, if based on that interaction, if the judge thinks that there's a less restrictive alternative to guardianship. And some of our judges have asked us to look at less restrictive means if after interacting with the person with the disability, they think that a less restrictive alternative is available. And then they will ask, do you want your mom, do you want your dad, grandma, aunt, brother to be your guardian? And if there is an objection from someone, then the judge is going to take that into account and allow another family member to petition if they want to. So all of the uncontested hearings in Cook County are on Zoom, although you can go in person to daily if you want to. It can all be done on the computer. It can be done on screens. And if you are, and then prior to the hearing, you just have to email all the documents to the judge. So the duties of the guardian, they make all necessary decisions for the ward involving health, education, where they live, but they are supposed to keep in mind to allow for self-reliance and autonomy and independence wherever possible, and to make decisions in keeping with the ward's best interest, and to keep the ward involved in decision making. The court retains power for the remainder of the guardianship. So you don't just go to court and that's it. You report to the court every year how the ward is doing. If a residential placement is necessary, you need the permission of the judge to do that. If the person comes into money, if there's an inheritance or a settlement, then you have to return to court to obtain an estate, and that involves court oversight. If there's ever a restoration or a partial restoration of rights, that's to go back in front of the judge. And then a guardian has extraordinary powers, but they cannot involuntarily commit a adult with a disability. Only the state can, and so that would involve a separate court petition. Like I said, there's that annual report that has to be mailed into the judge, and it's a very simple form. It's about a page and a half, and it just says where the person is living, if they've had any major medical events, are they in school or any adult programs, and is guardianship still necessary? And that's something that can be done without the assistance of a doctor or a lawyer. Illinois also requires a one-time guardian training, which is also done online. It's about an hour video, and then you send the certificate of completion to the judge. And that training is also available on the Illinois Guardianship and Advocacy Commission website. And it's very important to do that unless the judge decides to waive it. Like I said, we have a help desk at the Daily Center. We are in person most days that court are in session. Um, at the Daily Center Resource Center on CL 29, which is in the lower level. We also run a virtual help desk by appointment only, and anyone interested in services can call our main line to conduct a brief screening to verify that it's an appropriate case for our help desk. And if it is, then we schedule a phone appointment to gather the necessary information to complete all of the forms and then send them over with instructions on how to file and what to expect in court. So that is my presentation.